Hello, everyone out there in YouTube world, Facebook world, social media world, the world, wherever you're watching this episode today. Welcome to another episode of Musings with MGL. I'm your host, as always, MGL. Thank you for tuning in. Thank you for watching. As always, if you like my content, if you like what I have to say, please subscribe to the channel. Click the ding, ding, ding bell notification so you'll know when I post new content and you can get all the up-to-date information. So I really appreciate all the subscribers and the people who watch my episodes. They really help the channel grow. So thank you very much. Today's topic is another big, explosive, important, topical topic. That's what's going on out here today. And it's a question that I've been getting from a lot of people lately. And that's why I decided to do a video on it. So disclaimer in the front, as always, I am a lawyer. I practice mainly in criminal defense and firearm laws, but I am located in Florida. So 99.9% of the stuff you'll hear me say on here always relates to specifically Florida law. So if you live in another state, that's your disclaimer. Don't necessarily take what I have to say and use it in your own state, because I am 100% familiar with Florida laws, but other states may have different laws. The topic I'm going to talk about here today, though, probably would apply to most states because it's a general topic about what's going on in the world today. But just for specific references, I'm only talking about the state of Florida. But you'll find that what I have to say probably applies mostly to your state as well. So the topic for today is self-defense in a protest, all right? This is obviously a very important current topic that's going on out there, because with all the unrest that's going on in the country right now, you have a lot of protest going on, and you have a lot of civil, perfectly acceptable constitutional protests that most people in the world, including myself, support. And then, of course, you have the crazy over-the-top protest, which would be more properly classified as a riot or looting or murders or arson and all the other crazy things that go along with that. So as everybody's always trying to emphasize, there are two different groups in this scenario. So what I'm going to be talking about here today is what can you do, or what do you do in a situation where you find yourself kind of in the latter group, the anarchists, the rioters, the looters, the bad people, and how do you know when the situation you're in turns from the civil protest into the violence, at which point you can then use self-defense to protect yourself, okay? So it's a question that I'm getting a lot, again, as a criminal lawyer and defense attorney and a Second Amendment advocate. A lot of people are asking it online these days. At what point can I defend myself? At what point can I go to my firearm and exercise my right to self-defense? At what point does a peaceful protest of people blocking the road, preventing me from go to work, turn into a real threat of violence where I feel like I'm going to be dragged out of my car and beaten to death in the street, and so I need to pull my firearm? Or if they're protesting in my neighborhood, for example, we've all seen these people. Here they are. I'm going to put them up here for now. They're famous. Everybody knows who they are. If you've been watching anything about the news, if you know anything about Second Amendment world, everybody knows who these people are, okay? It's a couple located in St. Louis who there was a huge group of protesters that broke into their privately gated neighborhood and were marching down the street. There's a discrepancy in what occurred. The homeowners claim that they were trying to approach onto their property, that they were shouting threats at them, saying they were going to kill them and they were going to kill their dog. And there was an allegation that one of the protesters had two magazines full of bullets and was clapping them together and saying, "This one's for you, and we're going to live in your house when you're dead." That's what the homeowners say. Of course, there's no video of that. The people who are in support of the protesters say they never did anything, that we were just peacefully marching down the street to try and get to the mayor's house, and these nutballs came out and started waving their firearms around. So much like everything else in today's world, you got the half of the country on one side, and you got the half of the country on the other side. But it did spark a really good debate in the Second Amendment and in the legal community as to when you can exercise your right to self-defense. So here's the bottom line, okay? I'm going to make it as clear as I can. In Florida, you can only use deadly force or the threat of deadly force. So coming out of your house and waving your firearm around is considered the threat of deadly force if you are in imminent fear of death or great bodily harm, or you are trying to prevent a forcible felony. Okay, and if you go to the statutes in Florida, they have a list of what's considered a forcible felony. It's kind of what you consider would be the general stuff: murders, rapes, armed robberies, whatever. So if you see somebody robbing a store, if somebody's behind or at the counter pointing a gun at the clerk saying, "Give me all your money," and you're a customer and you want to pull your gun to prevent that forcible armed robbery from happening, you're permitted to do so. You're preventing a forcible felony. If you see somebody kidnapping a child or raping a woman or something, you have the right to produce your firearm to prevent that forcible felony from happening. That's one category. That's not usually where most people use self-defense, and that's not something that would probably deal with this protester issue. So the protester issue mainly has to do with yourself. If I'm in the vehicle driving down the road and all of a sudden they're blocking the traffic and I can't drive through, at what point am I allowed to either drive through and run people over with my car, which would be considered deadly force and a deadly weapon, or pull my firearm and try and get people away from the car so I can drive through? When is that line? The answer is when you are in imminent threat of death or great bodily harm. It has to be imminent, meaning right now. So generally, I would say if you're parked at in a line of cars and there's protesters blocking the street waving their signs, you're not going to be able to articulate that you are in imminent fear of death or great bodily harm. Okay, it may be annoying because you don't want to get to work, but just because somebody's blocking the road doesn't put you in imminent fear of death or great bodily harm, and you're going to have a hard time articulating that you were justified in running the people over, gunning it, or pulling out your firearm and brandishing it, or whatever you want to do, okay? Obviously, if you're in the car and people start surrounding it and they're trying to break the windows with tire irons and they're shouting out things like, "If we get into this car, we're going to kill you," they're trying to open up the doors, then you probably might be able to articulate that you are in imminent fear of death or great bodily harm because you're sitting in a car with people surrounding it, trying to bust your windows, trying to open up the door, and they're making statements like they're going to kill you if they can get into the car. Between those two extremes, okay, somebody trying to bust into your car with large groups of people saying they're going to murder you, pretty good situation where you could probably feel that you are an imminent threat. To people blocking the road with signs because they're trying to make a political point, not going to be able to do that. All the subtleties in between are going to be on a case-by-case basis, okay? That's all I can tell you as a lawyer. That's all any lawyer is going to be able to tell you. No lawyer is going to be able to give you a bright line rule and say something like, if there's 2 protesters, you can't shoot or run them over, but if there's 3, you can. If all the protesters are women, you can't, but if they're all big men, you can. Like, there are no bright line rules to govern this situation, okay? Every situation is going to be different. It's all going to be based on the articulable facts for your specific incident, for your specific situations. And you, if you decide to use deadly force or the threat of deadly force, you are going to need to be able to convey to a jury, most likely at the end of the day, that you were in imminent fear of death or great bodily harm. And it's not just you personally. In Florida, we have what's called a objective standard. Okay, subjective standard means me, MGL, I believe personally I was in fear. An objective standard is what would a reasonable person believe to be in fear. Those can be vastly different things. One person may be more susceptible to fear. They may have trauma in their past that makes them at a more heightened situation for what's going on, whereas another person may not. So the 6 jurors or 12 jurors, if you end up killing somebody in Florida, who are going to decide your fate, are going to have to look at it from an objective standard. What would a reasonable person in this situation feel they needed to do to protect themselves from imminent death or great bodily harm? You may get up there yourself and say, I've seen all these videos on TV and I was ultimately scared and I have a history of this and that. But the jury doesn't have to care what your position is. Their position is, what would a normal, ordinary, reasonable person do? So remember that, all right? It's not what your position is. But regardless, you are the one who's going to have to articulate to the jury through your defense attorney or whatever that you were in reasonable fear of imminent death or great bodily harm, and you had no choice but basically to run over these people and escape or pull your firearm. Are those people in St. Louis of the picture that I just showed you going to be able to do that? That's going to be up to them to be able to articulate. Now, again, St. Louis may have different rules. Again, this is Florida. But if I was applying the Florida standard to them, I would say personally, my personal opinion about that case is, if the people living there are telling the truth, if their story is accurate, that people were trying to come onto their property, people were yelling things like, we're going to kill you, or we're going to kill your dog, we're going to live in your home. If they are holding magazines full of ammunition and clapping it in front of your face saying, this one's for you, that I believe would probably rise to the level of being justified in using, brandishing basically their firearms, which would be what we would call the threatened use of deadly force. If the protesters are accurate and nobody said any of that, and all they were doing is marching down the street trying to get to the governor's house, and there were just too many of them, they'd broken a private gate to get into the neighborhood, not a private gate to get onto that particular property, but a private gate to get into the gated community. But they really are just marching down the road, maybe chanting, things that you don't politically or whatever agree with, but holding flags or whatever. But if they're not trying to come onto their property, if they're not calling you or threatening you in any way, if they're not brandishing firearms or magazines or whatever, it's literally just you saying, there's too many people surrounding my house and it scares me, then they're going to have a hard time showing that they were in reasonable fear for that. So a lot of it's going to come down to what, again, fact specific. What are the facts of the case, and what facts can be relayed to the jury and articulated in court, okay? So there's nothing about the fact that there are protests going on that changes the legal standard, okay? And you're probably going to find this in all 50 states, that no state that I can think of would probably have a law that says this is our standard for self-defense. However, if there's a protest, then this is our standard for self-defense. Like, that's not how it works. There's a standard in every state for when you can and can't use justified deadly force or threat of deadly force or self-defense, whatever language you want to use. There's a standard in every statute in every state that tells you what that standard is. And that standard applies whether somebody's breaking into your home to rob it, whether somebody's breaking into your home to make a political statement, whether somebody's trying to break into your car to carjack you, or whether somebody's trying to break in your car because they're trying to, make a political point, or they're just crazy and rioting and looting, or they're Antifa that's been paid by George Soros or whatever. The same standard's going to apply, okay? So you can't just plow through protesters who are blocking the road because you feel like they shouldn't be doing that because you got to get to work, okay? You can't just pull your firearm out at people that might be marching in your neighborhood if they're not doing anything but marching down your street, okay? You are going to have to, again, have to articulate to the jury or the judge, whoever the legal arbiter is in your state, or obviously here in the state of Florida, it's a jury, that you are in imminent fear of death or great bodily harm. If you can do that, then like every other people who use self-defense, then you're going to be justified in using it. If you can't do that, then you're going to be convicted of whatever the charge is going to be: aggravated assault, improper exhibition of a firearm, whatever you want to call it. So I just wanted to clarify that as best as I could. And the problem is, I know people want specific answers. Like, I get bar exam style questions. Well, what if I'm in my car and my wife's in my car and the kid's in the car and we're stopped at the corner and there were two guys and they were being nice, but then the third guy came up and he gave me the middle finger, and then somebody was walking around the back and my kid starts crying. Like, they're like detailed scenarios, and they want me to give them a thumbs up or thumb down. Well, if that's the case, then fire away. Or that's not the case, you're just going to have to sit there and take being called names. I can't give you those answers. No lawyer can give you those answers. If any lawyer gives you specific answers to your bar exam scenario, they're committing malpractice, because you're not supposed to do that, okay? Again, I can give you extremes, which you would probably be okay, but even then, there's never any guarantee. It's all going to depend on the specific facts of your case, how they can be articulated to a jury, either by the state attorney's office or the defense attorney through the witnesses and the evidence in the case. Every case is going to be different. So I just wanted to clarify that, because people are getting frustrated that they can't get specific answers and their scenarios are getting ridiculously crazy. out there with what's going on. They really want hard proof answers, and nobody can really give them to them. I can give you my best guess about things, and I can give you what the status of the law is, but ultimately, you are the person who's going to be in that situation, so you have to do what you feel you need to do to protect yourself and your family, and then whatever consequences come down the line from that, you'll have to deal with them in the legal system, just like everybody else does. But just be careful out there in the protest. Don't be overzealous. Don't get angry and cuss at the protesters or try and pick fights with protesters or whatever. Go about your daily life as best you can. Protect yourself and protect your family. But you have to do it within the legal means. You can't just be willy-nilly because things are crazy out there. So just wanted to shoot that out there. Message today. It's probably not the definitive answer that people want. But read your statutes in your state. Follow the self-defense rules and the laws in your state. And you should be fine. But you're always going to have to follow those rules, and you're going to have to be able to articulate why you follow those rules and what the situation you were in order to avoid lengthy prison time or whatever. So be careful out there. No matter what, I wouldn't walk around. I wouldn't come out in front of your house and put your finger on the trigger like that. That is, as Ben pointed out, a horrible trigger discipline by the wife there. The husband looks like he's doing okay, but my guess is he's never held an AR-15 or any kind of rifle like that in his life because, look at him. But regardless. So enough picking on those people. They're tired of it. They've been getting their own death threats and harassments and stuff after that. So I feel bad that this happened to them, but it's happening to a lot of people out there. So if it happens to you, remember what I had to say here today. And as always, protect yourself. So stay safe, stay vigilant, and as always, carry on.